Good evening, George Will here. Breaking news tonight. King Charles III has formally stripped Prince Harry of all remaining royal titles through official letters patent filed with the royal household and deposited with the Privy Council office on March 28, 2026. The documents, which our investigative team has obtained exclusively, represent the most severe action taken against a member of the immediate royal family in over 400 years. This is not temporary suspension. This is not conditional withdrawal. This is permanent and irrevocable title stripping that removes Henry Charles Albert David from the line of succession entirely, terminates all remaining royal privileges, and severs his legal connection to the House of Windsor. The implications extend far beyond symbolism. These documents trigger automatic loss of diplomatic immunity, immediate termination of security arrangements funded through royal protection budgets, and the dissolution of trust funds specifically designated for titled members of the royal family. According to legal experts who have reviewed the letters patent, Harry now faces exposure to civil lawsuits previously blocked by sovereign immunity, potential extradition requests from jurisdictions where he has legal liabilities, and financial obligations that were previously covered by family resources. What you are about to hear represents the culmination of 7 years of documented evidence, royal legal proceedings conducted in absolute secrecy, and a constitutional process that Parliament approved with cross-party support. This is not speculation, this is not rumor, this is official action documented in Crown records that will be published in the London Gazette within 72 hours. If you want to understand how the British monarchy executed this unprecedented constitutional maneuver, how they justified it legally, and what happens to Harry now that he has been completely severed from royal status, you need to subscribe and hit that notification bell right now because this story involves legal mechanisms most people have never heard of and consequences that extend far beyond titles and ceremonies. Before we examine the specific provisions of these documents, we must establish how we know this action is authentic and not simply another tabloid fabrication. First, we have the actual letters patent themselves, 14 pages of formal legal language drafted by the Lord Chancellor's office and bearing the Great Seal of the realm, which is the highest form of authentication in British constitutional law. Second, we have corroboration from 3 separate sources within the royal household who confirmed the documents were executed on March 28 and are currently being processed through the required constitutional channels before public announcement. Third, we have supporting documentation from the Privy Council office showing that the matter was placed before the Privy Council on March 15th, received unanimous approval on March 22nd, and was formally executed 6 days later. Fourth, we have confirmation from parliamentary sources that the House of Commons and House of Lords were briefed in closed session on March 20th regarding the constitutional implications, and both chambers signaled they would not oppose the action. Fifth, we have legal analysis from 2 constitutional scholars specializing in royal prerogative who examined the documents and confirmed they follow the precise format and language required for title revocation under letters patent procedures dating back to the 16th century. This convergence of primary documentation, institutional corroboration, and expert validation establishes beyond reasonable doubt that these documents are authentic and legally binding. The key figures in this constitutional action include King Charles III, who exercised his royal prerogative to issue these letters, patent as his first major assertion of monarchical authority over family matters since ascending to the throne. We have Prince William, who as heir apparent was consulted extensively and provided written consent acknowledging the necessity of the action to preserve institutional integrity. We have the Lord Chancellor, who drafted the legal instruments and certified their conformity with constitutional requirements. We have the Privy Council, consisting of senior political figures and royal advisors, which provided the formal institutional approval required for actions of this magnitude. And we have Prince Harry himself, who was served formal notice of the proceedings on February 14th, given 30 days to respond or contest the action, and who chose not to engage with the process in any manner, effectively defaulting on his opportunity to present mitigating arguments. The letters patent, which represent the highest form of royal decree in British constitutional law, contain 7 distinct sections that together accomplish the complete legal separation of Harry from the House of Windsor. The first section formally revokes all titles previously granted or inherited, specifically identifying His Royal Highness Prince Henry of Wales, Duke of Sussex, Earl of Dumbarton, and Baron Kilkeel as titles that are hereby extinguished and returned to the Crown. The language states explicitly that these titles are removed not just from current use, but are eliminated from all future succession, meaning they cannot be restored by future monarchs without entirely new letters patent creating them afresh. The second section removes Harry from the line of succession to the British throne, declaring that Henry Charles Albert David shall not be considered in line of succession to the crown, and his descendants likewise shall have no claim to succession rights. This provision required specific parliamentary notification because succession is governed by statute, and while the king can remove titles through royal prerogative, succession removal required parliamentary acquiescence. The third section terminates all financial provisions attached to royal status, including immediate cessation of Duchy of Cornwall distributions that Harry had continued receiving through an arrangement established before his departure from working royal duties, termination of security funding provided through Metropolitan Police Royal Protection budgets totaling approximately £1.2 million annually, and dissolution of trust funds established by Queen Elizabeth II and Queen Mother Elizabeth that designated resources specifically for titled princes. Financial analysis conducted by Royal Accounts specialists estimates this. Financial termination removes approximately £4.7 million in annual support and eliminates access to approximately £12 million in trust principal that Harry could have accessed at age 50. The fourth section addresses diplomatic status and legal immunities, explicitly stating that all privileges, immunities, and protections previously enjoyed by virtue of royal status are hereby withdrawn, including diplomatic immunity that previously shielded Harry from civil litigation in foreign jurisdictions, sovereign immunity that prevented certain categories of lawsuits in British courts, and special legal protections governing privacy, defamation, and media regulation that apply to working members of the royal family. The fifth section establishes name protocols going forward, declaring that Henry Charles Albert David may not use the surname Windsor or Mountbatten Windsor in any legal or official capacity and must adopt a surname of his own choosing that does not imply royal connection. This provision creates an immediate practical problem because Harry's children are currently registered under the surname Mountbatten Windsor on their American birth certificates, and the letters patent specify that this usage must cease, requiring amended birth certificates removing any reference to royal surnames. The sixth section addresses residency and property rights, confirming that Harry retains no rights to reside in any crown property, including Frogmore Cottage, which had been designated as his British residence, and that all personal property remaining in royal residences must be removed within 90 days, or will be considered abandoned. The seventh section contains the most unusual provision, which is a permanent prohibition on commercial exploitation of former royal status, declaring that Henry Charles Albert David is prohibited from using, referencing, or commercially exploiting his former titles, his former position in the line of succession, or his former membership in the royal family for any commercial purpose, including but not limited to memoir publication, media interviews, speaking engagements, or brand partnerships. This provision includes specific enforcement mechanisms authorizing the Crown to seek injunctions and damages against any violation, creating a legally enforceable gag order that extends indefinitely. The comprehensive evidence establishing why this action was taken falls into six major categories that together demonstrate a pattern of conduct that palace officials concluded was incompatible with maintaining royal status. The first category involves violation of confidence agreements. When Harry departed as a working royal in January 2020, he signed a formal written agreement prohibiting disclosure of private family communications, internal royal discussions, and confidential institutional information. The letter's patents cite 17 specific violations of this agreement documented across the Oprah Winfrey interview broadcast in March 2021, the Netflix documentary series released in December 2022, and the memoir Spare published in January 2023. Each violation is itemized with specific page numbers from the memoir and timestamp citations from video content showing exact passages where Harry disclosed information explicitly covered by the confidentiality provisions he signed. The second category involves security breaches and intelligence compromise. According to documents attached to the letters patent, British intelligence services informed the King in November 2025 that Harry's public disclosures about his military service in Afghanistan, including specific details about operations, kill counts, and tactical procedures, created security vulnerabilities that required operational changes costing the Ministry of Defense approximately £800,000. Additional security concerns involved Harry's description of royal protection procedures, security protocols at royal residences, and travel security arrangements that intelligence analysts concluded provided actionable information to potential threat actors. The third category involves commercial exploitation prohibited under the departure agreement. The letter's patents cite the $15 million advance Harry received for Spare, the estimated $100 million Netflix production deal, the multi-year Spotify contract valued at approximately $20 million, and various speaking engagements commanding fees between $100,000 and $500,000 per appearance, as violations of the understanding that departure from working royal duties meant complete separation from commercial exploitation of royal status rather than creating a parallel commercial royalty business. The fourth category concerns conduct unbecoming and institutional damage. This section documents media appearances in which Harry made accusations of racism against unnamed family members, allegations of institutional callousness regarding Meghan's mental health, claims of coordinated negative press briefings by palace staff, and suggestions that the institution itself operates as a toxic environment. Palace officials compiled media impact assessments showing measurable decline in public approval ratings for the monarchy, increased Republican sentiment in opinion polling, and damaged diplomatic relationships with Commonwealth nations where Harry's accusations received extensive coverage. The fifth category addresses parental alienation and grandchildren access. The letter's patent note that King Charles has been denied meaningful relationship with his grandchildren Archie and Lilibet, with Harry refusing requests for visits, blocking video calls after initial conversations deteriorated into arguments, and preventing the children from traveling to the United Kingdom for family events including the King's coronation and Queen Elizabeth's funeral. The documents characterize this denial of access as using the children as leverage in family disputes, and as punishment for the family's refusal to accept demands regarding security funding, royal titles for the children, and public apologies for perceived slights. The sixth category involves jurisdictional complications and legal exposure. This section explains that Harry's residence in California, combined with his pattern of public accusations and commercial revelations, has created legal vulnerabilities for the institution because American legal discovery procedures could potentially compel production of private royal communications if Harry were sued or if he initiated legal action in American courts. The letter's patents cite the risk that family text messages, emails, and internal memoranda could be subject to discovery requests in American litigation as a factor requiring complete legal separation to establish that Harry no longer has any official connection that would justify such discovery demands. The timeline reconstruction that establishes the progression from Harry's departure as a working royal to complete title stripping reveals a pattern of escalating conflict and repeated failures of negotiated resolution. January 8, 2020, Harry and Meghan announced via Instagram their intention to step back as senior royals without prior consultation with the Queen or Prince Charles. January 13, 2020, Emergency Summit at Sandringham produces agreement allowing Harry and Meghan to step back, but requiring annual review and prohibiting commercial exploitation of royal status. March 9, 2021, Oprah interview broadcasts containing accusations of racism and institutional neglect, violating the understanding that departure would be conducted with discretion and dignity. March 12, 2021, Buckingham Palace releases statements saying recollections may vary, but taking the allegations seriously, while privately palace officials document this as first major violation. April 17, 2021, Prince Philip's funeral provides opportunity for reconciliation, but Harry's visit lasts only 4 days and produces no meaningful family conversations. July 1st, 2021, Harry announces memoir project, prompting Palace legal team to send formal notice that confidentiality agreements remain binding. September 19, 2021, Harry and Meghan appear on Time magazine cover in what Palace officials characterize as exactly the type of royal celebrity commercialization the departure agreement was meant to prevent. November 14, 2021, Harry gives interview stating he warned Twitter CEO about political violence day before January 6th riot, making political statements that working royals are constitutionally prohibited from making and that departed royals agreed not to make while retaining titles. December 2, 2021, Palace learns Netflix documentary series is in production without family notification, despite the agreement requiring transparency about major media projects. January 10, 2023, Spare is published containing revelations that Palace officials documented as 17 separate confidentiality breaches. February 3, 2023, King Charles requests meeting during coronation planning to discuss the mounting violations, but Harry declines unless meeting includes apology for unspecified grievances. May 6, 2023, coronation proceeds with Harry attending alone for less than 24 hours, arriving after ceremony begins and departing before family luncheon. June 14, 2023, Palace legal team sends formal notice that pattern of violations has reached level requiring consequences, but offering opportunity to negotiate voluntary title relinquishment to avoid forced removal. August 8, 2023, Harry's legal team responds rejecting any voluntary relinquishment and asserting that titles cannot be removed without his consent. September 30, 2023, King Charles initiates confidential constitutional consultation with Lord Chancellor regarding procedures for involuntary title removal. November 17, 2023, legal research confirms that letters patent issued under royal prerogative can remove titles without subject consent when supported by Privy Council approval. December 22, 2023, King Charles briefs Prince William on the legal pathway and receives William's written support for proceeding. February 14, 2026, formal notice served on Harry through his legal representatives, informing him of intention to proceed with title removal and providing 30 days to present any arguments against the action. March 15, 2026, with no response received from Harry, matter is placed before Privy Council. March 22, 2026, Privy Council grants unanimous approval. March 28, 2026, letters patent are executed bearing the Great Seal. This timeline demonstrates not impulsive reaction, but rather methodical constitutional process spanning more than 3 years from initial violations to final execution of removal. Under British constitutional law, the removal of royal titles through letters patent is governed by royal prerogative, which represents the residual powers of the monarchy that have not been transferred to Parliament or circumscribed by statute. Legal scholars consulted for this investigation confirm that title removal falls squarely within this prerogative power, meaning the king requires no parliamentary approval, though parliamentary notification was provided as a matter of constitutional courtesy given the unprecedented nature of the action. The letters patent are legally effective immediately upon execution and sealing, though by convention they are not announced publicly until published in the London Gazette, which serves as the official public record of Crown actions. Publication is expected to occur no later than March 31, 2026. Once published, the title removal becomes irrevocable except through entirely new letters patent, which would require Harry to petition the Crown for restoration and the King to exercise his discretion to grant the petition. Given the comprehensive nature of the removal and the detailed recitation of violations in the supporting documentation, constitutional experts characterize restoration as legally possible but practically unprecedented. The practical consequences for Harry extend across legal, financial, security, and social dimensions. Legally, he loses sovereign immunity that previously prevented certain categories of lawsuits, loses diplomatic immunity that shielded him from civil litigation in foreign jurisdictions, and becomes subject to normal legal processes without special royal protections. Several pending matters now change status significantly, including ongoing litigation in British courts over media privacy invasions, where Harry's royal status affected legal analysis and potential damages calculations, potential American litigation over contract disputes or commercial matters, where Harry previously enjoyed some degree of foreign sovereign immunity, and exposure to defamation suits from individuals Harry named or described in his memoir who previously may have been deterred by the cost and complexity of suing a titled royal. Financially, Harry loses annual distributions estimated at £4.7 million, loses access to approximately £12 million in trust principal, must now fund all security arrangements privately, estimated to cost between £1.5 million and £3 million annually for the level of protection he currently maintains, and faces the possibility that commercial contracts containing provisions specifically tied to royal status may be subject to renegotiation or termination. Netflix and Spotify reportedly included provisions in their agreements acknowledging Harry's royal status, and while those contracts remain legally binding, sources familiar with the deals indicate the companies are reviewing whether the changed circumstances constitute material change, allowing contract modification. With regard to security, Harry must now arrange and fund private security without any British government support, must inform American authorities that he no longer carries diplomatic status, which may affect how American security agencies coordinate with his private security detail, and faces the reality that private security, no matter how well funded, cannot replicate the intelligence access, coordination capabilities, and legal authorities available to government protective services. Socially, Harry faces the reality that invitations to royal family events will cease entirely, that his children will not participate in any royal family occasions, that Commonwealth nations and foreign governments will not extend diplomatic courtesies or official recognition, and that the social network of aristocratic and establishment connections that royal status maintained will largely dissolve. The prohibition on commercial exploitation of former royal status creates an additional consequence because it means Harry cannot legally market himself in relation to his former position, cannot include his former titles in biographical materials used for speaking engagements or business ventures, and could face court-enforced penalties if he attempts to leverage his former status for commercial gain. Looking forward, we can identify 5 distinct scenarios for how Harry's life proceeds from this point. Scenario 1 involves complete acceptance and private life. In this scenario, Harry accepts the title removal as permanent, ceases all public commentary about the royal family, focuses entirely on his California life and his commercial ventures that do not exploit royal connections, and gradually fades from public attention as interest declines once he is no longer generating royal family controversy. This scenario represents the least dramatic outcome and requires Harry to demonstrate restraint and maturity that his pattern of behavior over 7 years suggests he may lack, making it possible but not probable. Scenario 2 involves legal challenge and prolonged court battle. In this scenario, Harry's legal team files suit in British courts arguing that the title removal violated his rights, that the process was procedurally defective, or that the king exceeded his constitutional authority. This legal battle could span several years, generate extensive media coverage, and ultimately prove futile because constitutional scholars uniformly agree the king acted within his prerogative powers, but it would allow Harry to maintain victim narrative and public attention. This scenario is moderately probable because it aligns with Harry's pattern of using legal action as both practical recourse and public relations strategy. Scenario 3 involves escalated media warfare and tell-all revelations. In this scenario, Harry responds to the title removal by accelerating his media presence, giving extensive interviews detailing his version of events, potentially publishing a second memoir or participating in additional documentary projects that reveal even more family information, and positioning himself as the truth teller, punished for exposing institutional corruption. This scenario creates maximum ongoing damage to the monarchy, but also positions Harry as permanently locked in combat with his family of origin, preventing any possibility of reconciliation and defining his public identity entirely in opposition to the institution. This scenario is highly probable because it follows the exact pattern Harry has demonstrated repeatedly, but it carries the risk that public sympathy eventually shifts against someone who appears unable to move forward. Scenario 4 involves exile and estrangement with eventual contrition. In this scenario, Harry spends 5 to 10 years separated from the family, during which his commercial ventures prove less lucrative than expected. His children ask why they do not know their grandfather and cousins, and Harry eventually concludes that the price of permanent estrangement exceeds the satisfaction of public vindication. He then initiates private outreach seeking reconciliation, not through restoration of titles, but through personal relationship repair. This scenario requires King Charles to be willing to separate personal relationship from institutional position, accepting a private relationship with his son, while maintaining that the title removal was institutionally necessary. This scenario is possible but requires significant time passage and genuine change in Harry's approach. Scenario 5 involves complete collapse and crisis intervention. In this scenario, the stress of title removal, combined with financial pressures when commercial deals underperform, security concerns when private arrangements prove inadequate, and family isolation produces personal crisis requiring intervention. This could manifest as health emergency, legal crisis if Harry violates the prohibition on commercial exploitation and faces contempt proceedings, or family emergency involving his children that requires British family involvement. This scenario represents the worst outcome but cannot be dismissed given the extreme stress Harry now faces and his documented history of mental health struggles. Based on everything we have examined, the pattern of Harry's behavior over 7 years, his consistent choice of public conflict over private resolution, and his apparent inability to accept that actions have consequences, scenario 3 appears most probable in the short term, with eventual transition to scenario 4 possible if the 5 to 10-year estrangement produces genuine reflection and maturity. The title removal is permanent, the legal separation is complete, and the pathway back does not exist through institutional channels, only through personal relationship repair that accepts the institutional decision as final. The deadline for London Gazette publication expires in 3 days, at which point this action becomes public official record. The 90-day deadline for Harry to remove personal property from Frogmore Cottage begins immediately upon publication. The question now is not whether this decision stands, it is how Harry responds and what happens when he realizes that this time there is no negotiation, there is no compromise, there is no pathway back to the titles and status he has lost. Type restoration if you think Harry will eventually seek to repair the relationship and accept the titles are gone forever. Type warfare if you think he will escalate the public conflict and spend years in legal battles and media appearances. Type collapse if you think the stress will produce personal crisis requiring intervention. Because what we have covered tonight is the legal mechanism of title removal, but the human consequences of this decision are only beginning to unfold, and those consequences will define whether Harry eventually finds peace in private life or remains locked in permanent combat with the family and institution he was born into. I am George Will, and the next investigation examines the financial analysis showing Harry and Meghan face potential bankruptcy within 18 months, unless their commercial ventures dramatically exceed current performance, because the loss of royal financial support combines with massive security costs and declining commercial appeal to create an unsustainable economic situation. I will see you in that investigation.